I am next of kin, so why should a lasting power of attorney also be in place?
The base position and the issue is that many people believe that next of kin is a form of status that affords them an ability to make decisions on behalf of a relative who lacks mental capacity. Unfortunately, the reality is far from the case. Next of kin has no legal status whatsoever, and in the matters of continuing healthcare funding, whilst the views of the family will of course be taken into consideration, it has no legal status, and therefore an individual is unable to make decisions that will bind the NHS or care providers or anything of that nature. So the clear benefit of having a lasting power of attorney ensures that the individual does have that legal authority to be able to make decisions on behalf of the relative where and when they have lost mental capacity to be able to make those decisions for themselves. Now, the individual themselves has to, while they retain mental capacity, make the decision and agree to the appointment of the individual to act as a lasting power of attorney for them. And that's crucial. It has to be by their consent and with their authority. There are two types of lasting power of attorney. One is for property and financial affairs, and the other is for health and welfare. It's crucial, we would advise, that where securing a lasting power of attorney, that both aspects are undertaken. Often it's the case that for whatever reason, be it incorrect advice or a misunderstanding of the process, that people elect only to have a lasting power of attorney for property and financial affairs. And this can cause difficulties, which whilst not insurmountable, certainly can be problematic in latter stages where an individual has lost mental capacity. By way of an example, if an individual only has a lasting power of attorney for property and financial affairs, sometimes certain NHS trusts can refuse to disclose hospital records relating to a patient, saying that the property and financial affairs lasting power of attorney does not grant the lawful authority, and that is only provided by a lasting power of attorney for health and welfare. Now, this is something that we don't agree with necessarily, especially in the matters of continuing healthcare funding, because there is a very clear argument that we are investigating to see whether an individual ought to be paying for their care, and accordingly, how can you have a situation where a property and financial affairs power of attorney does not have the authority to be able to interact with individuals in that investigation? Should someone be paying for care is clearly a financial matter, ergo a property and a financial affairs power of attorney ought to have the correct standing to be able to be applicable in that scenario. As I say, there are ways around these things, but in order to minimise conflict, minimise delays and minimise issues, when seeking to secure lasting power of attorney, it would be our view that the individual would be best placed to ensure that they have property and financial affairs and a lasting power of attorney for health and welfare as well.
But what happens if my relative lacks mental capacity and hasn't put a power of attorney in place?
The point is that at the point mental capacity is lost, an individual can no longer consent or grant the authority to enter into a lasting power of attorney, appointing an attorney to act on their behalf. As such, that decision then has to be made by the court and an application made to the Court of Protection to make that decision on behalf of the individual patient, because they are unable to do so themselves. That process is requesting a deputyship be put in place, which is the same as, in many ways, a lasting power of attorney, but instead of the individual having made the application while they retain mental capacity, the court is appointing an individual to act on the patient's behalf. So, the issues with that is that, first and foremost, the cost of an application to the Court of Protection in terms of court fees is far greater than the cost of an application for a lasting power of attorney, first and foremost. Secondly, the time it takes for the application to be processed, which of course, as we've just talked about, quite literally time is money in these situations, can be far longer. Any delays can cause problems, can cause issues, and ultimately can result in greater amount of care fees being incurred. For this reason, if an individual retains mental capacity and there is any danger that they may lose it in the future, for example, they suffer a condition such as dementia or Alzheimer's, where ultimately it's likely that, unfortunately, due to deterioration, they may lose their mental capacity. If they wish to enter into a power of attorney to appoint someone to act on their behalf, they should do so as soon as possible before mental capacity is lost. At Compass Continuing Healthcare, we are experts in matters exclusively of continuing healthcare funding and the issues related to it. If you have any questions or queries or problems relating to continuing healthcare, we would be more than happy to have a free, confidential, no obligation discussion with you. We can be contacted directly on 0121 227 8940. Alternatively, you can complete a survey on our website, which in itself should be a useful resource of information for you regarding continuing healthcare funding matters. Our web address is www.continuing-healthcare.co.uk. Thank you.